Do you actually have a court order that orders Mr. Smith to pay child support to Miss Smith?
Yes.
You do? No offense, your interpretation is not the same thing as me reading it specifically from the court order, okay?
So he doesn't owe me child support?
Not after May 21st, not after May of 2021, he doesn't. Whatever he owed
I
you.
still have Matthew.
A woman joins a Zoom court hearing confidently holding up what she claims is a court order saying the father of her child owes her support, and from that moment forward, everything goes downhill fast. You can immediately tell she's about to treat this hearing like a personal live stream instead of an actual legal proceeding. She starts debating legal terminology through her webcam as if she's the attorney in the case. But the energy feels more like a casual Facebook rant than a controlled court appearance, and that's the wild thing about Zoom court people get too comfortable. They forget this isn't social media. It's still a courtroom, the judge still has full authority, and contempt is still very real even over Wi-Fi. And here's the important part most people don't realize. Simply flashing a paper court order means nothing unless it's officially filed, verified, and recognized in the court system. Emotion isn't evidence, and confidence isn't the same as compliance. Why do you think so many people walk into court acting entitled these days? Let's get into it, because this case escalates fast.
It's in the District Court of Newton County, Texas, and it's in the interest of Barry Grace and Matthew Smith. Both parties are now present.
How is Matthew covered with health insurance?
I have Medicaid.
And has Mr. Smith paid you any money directly?
No, ma'am.
Since your last order? Okay. Did you have any safety concerns with your personal information being in this order?
No, ma'am.
I pass this witness, Your Honor. Mr. Smith, where are you working?
I'm working at Excel Mulching in Carthage, Texas. Well, that's where their office is.
How much are you making per hour?
Making $25 an hour.
And how many hours a week do you work?
I've only been working 50 for last month or so. Generally, we work 60 hours, but sometimes, like now, it's just slow, so we're only working 50.
Do you have any health insurance available through your employer?
I'm pretty sure that they offer it, but I haven't been here long enough that they've offered it to me.
How long have you been there?
Getting close to 90 days.
At this time, I asked the court to take judicial notice of the prior order.
The court will take judicial notice of its own file.
Were you working at Excel Mulching at the time of the last order in 2019?
I'm not sure what order that was. That's when they added some behind payments to it or something.
Have you previously worked at Excel Mulching?
Yes, ma'am. I've worked here on and off since 2013.
Okay, you've been back there for the last 90 days.
Yes, ma'am. My kind of work pipeline is just you start a job, and once it's over, you have to find another job. Might last a couple months. Might last 9 or 10 months, you know.
I pass this witness, Your Honor.
Call your next witness.
I have no more witnesses, and I want to pretty much non-suit the modification and just get a confirmation of arrears.
Do you actually have a court order that orders Mr. Smith to pay child support to Miss Smith?
Yes.
You do?
Yes, Your Honor.
When was that signed?
That was signed November the 20th of 2019.
All right. Let's see if you actually have that. Y'all be patient with me for just 1 second, okay?
Mm-hmm.
I got a court order signed by the judge on September the 11th of 2019. In this court order, it says that apparently there was some earlier custody issues between Mr. and Miss Smith and some third parties.
Yes, sir.
All right. So in this new custody issue from 2019,
the new custody.
That's okay, Miss Smith. I've got the paperwork right in front of me. Okay.
Yes, sir.
I don't. No offense. Your interpretation is not the same thing as me reading it specifically from the court order. Okay.
Yes, sir.
All right.
And there was also one titled Nunc of Prior Order. That was after that one.
All right. So there were 2 children in the court order, Gracie and Matthew. Miss Smith was named as the primary joint managed conservator. Mr. Smith was named as a possessory conservator. Amended order, it said that he was supposed to pay her $750 a month.
Yes, Your Honor.
Beginning October 1st. Okay. And the state has non-suited its request for modification.
Yes, because when we originally filed it, his wages were a lot lower, and now they've kind of gotten back to similar what it was in the prior order.
Okay. So based on what we just lost. Hold on, Mr. Smith. We lost Miss Smith. Of course, that would happen as soon as I had gotten this all figured out. We were getting ready to get finished. You got a problem in this case, Miss Leonard, a big problem.
Okay.
I have a question, Your Honor.
Hold on, I can't do anything until Miss Smith gets back, okay?
Are you talking about the any child?
Yep.
Okay.
This child support ended as soon as Grace graduated from high school. Mr. Smith, when did Grace graduate from high school?
That's what I was going to tell you, Your Honor. In 2020, she's married now, and she's been living with her husband for 2 years. She lived with me at the end of 2019 for about 6 months.
Okay,
that's when she graduated.
That doesn't answer my question, Mr. Smith. When did Grace graduate from high school?
2020, I believe.
Okay.
Let me just be honest here. This entire situation feels like a mix of confusion and pure entitlement. Yes, child support cases are emotional. But if you don't even understand the terms of your own court order, maybe pause before accusing someone else of violating it. I've seen people wave around paperwork like it's a golden ticket, when in reality, they haven't even read the fine print. That never ends well, especially in family court where precision matters more than passion. What blows my mind is how often people treat legal documents like they're optional suggestions and then act completely shocked when the judge pulls up the actual record. At the end of the day, both parents have a responsibility to fully understand exactly what the order states before turning it into a battlefield. The court system already moves slow. It doesn't need personal drama disguised as legal arguments. It's not about who speaks with the most emotion. It's about who has their facts straight and can back them up. And right now, this doesn't look like a legal dispute. It looks like a misunderstanding turning into a circus. But what do you guys think? Is this just someone confused, or are we witnessing straight up entitlement? Let's get back into it.
So that means her child support would have ended in October of 2020, even though she graduated 4 or 5 months before that. All right. So
we do need to modify
2020.
And that was my question.
And unfortunately, your pay record is also incorrect, Ms. Hill Leonard, because your pay record continues this child support, which should have stopped on October the 30th of 2020.
Okay.
I mean, you started.
The state does ask for the modification, and we'll just have to get the pay record fixed.
Yeah,
at a later date.
You obviously have the right to start it up again because you have a child that's still under 18, but you can't.
We have to fix the pay record for the confirmation.
Not that, but you got to fix that court order from 20.
Yeah. So I want to do the modification, and then we'll just not suit the confirmation of arrears. So that's in reverse.
Well, Miss Smith is still not joining us. Mr. Smith, can you still hear me? Yeah.
Yes, sir.
All right. So look, this is what we got here. I got one child that's still under the age of 18.
Yes, sir.
And you need to be paying child support for that child.
Yes, sir.
But unfortunately, the court order that was done in 2019 didn't order you to pay child support for that child.
Right.
Because the court order says that you pay $750 a month until any child, oh wait, that might be her. Look, that is her. Miss Smith, I have reviewed all of the prior court orders in this case, and there is a major problem with the court order that was done in 2019, okay? I'm going to put this up on the screen so you can see it. You see where it says that Mr. Barry Glenn Smith Jr. is supposed to pay you $750 a month beginning October the 1st?
Yes, sir.
You see right there where it has the number 1? You see where it has
the child reaches 18 years of age, because I have two that are now 18.
Well, the problem is, you see where it says any child reaches? You see where that says by 1?
Uh-huh.
All right. That means when any of the 2 children you had from this court order ages out, his child support stops.
Well, that's why I haven't been getting any.
It may be. I just know that the court order says what it says. So Mr. Smith's child support should have ended in October of 2020 when Grace turned 18.
Well, she didn't graduate till May.
Oh, she didn't graduate till the next May 2021.
Yes, sir.
Okay, well then it should go through May of 2021, but it's supposed to stop then.
But why when I still, I mean, I get, why was it written like that? I guess is my question.
I don't know. I'm not the attorney who wrote it, so I don't know why it was written that way.
Okay. So he doesn't owe me child support?
Not after May 21st, not after May of 2021, he doesn't. Whatever he owed you.
Still have Matthew.
Well, that's what I'm saying. The court order, the way this court order is written, he's not ordered to pay you child support for that child.
Do you mean I have to go back to court?
No, they've got a modification now. I can fix this today.
Because that's not fair that I know that Grace aged out, but Matthew has not aged out.
I agree. It's not fair, but I can't change the court order in the past, Miss Smith. All I can do is fix it from this point forward.
So all these months, Barry doesn't owe me anything.
He doesn't owe you anything from May. He doesn't owe you anything from June of 2021 until now. There was no child support ordered for that period of time. Okay? I didn't create the order, Miss Smith. I didn't write it, and I didn't sign it. Somebody else did all those things. But that's clearly what the court order says. That's why we don't use any children in court orders. Yep, we don't do that any child stuff. Okay?
Yes, sir.
I don't agree with it, but I can't go back in time and fix it, Miss Smith. The law doesn't allow me to do that. All right, Miss Smith is here. Miss Hill Leonard, you can call your next witness.
Miss Smith?
Yes.
Just to make sure, you said that when did Grace graduate?
I don't know. She was born in 2002, so 21 probably is how that worked. That's when, and it was in May when she graduated.
Okay.
You don't owe me nothing.
What this situation really shows is just how chaotic things get when people don't fully read or verify what's actually written in their court orders. And honestly, I don't even put all the blame on either parent. Half the time it's a result of rushed paperwork, miscommunication, or a lawyer checking boxes without double checking the details. I've seen judges try to fix these sloppy mistakes years later, and trust me, it is never a quick process that if you're going to drag someone into court, especially over money, your paperwork better be airtight because emotions do not win cases. Evidence does. People love to argue fairness, but the court doesn't run on feelings, it runs on whatever is officially on file. And this is a perfect example of how one missing line, one overlooked detail, can change the entire outcome and flip thousands of dollars in the opposite direction. If I were him, I'd be relieved it went in my favor, but I'd also be on high alert. Because when the system glitches like this, it usually comes back to correct itself later. Just because you got lucky today doesn't mean the fight is over tomorrow.
Is not for people to do.
I passed this witness, Your Honor, and I call Miss Shaw. Where do you work?
I work for the Office of the Attorney General.
And what is your role in the Office of the Attorney General?
I'm a financial specialist.
Okay. And in your role, are you able to obtain income information for the non-custodial parents?
I am.
And what have you found for the past year for Mr. Smith?
I found that he averaged $57,302.32 for the last 4 quarters.
And so the monthly average was
$4,775.19.
Were there any other court orders for any other children?
No, I did not find any.
Okay. I passed this witness, Your Honor.
Your next witness.
I have no more witnesses.
Did the state rest?
Yes, Your Honor.
All right. Well, it's here, so I need to try to get it fixed and worked out. Ms. Smith, I have just placed on the record a copy of the pay record in your case with Mr. Smith. Is it okay if I look at this pay record?
Yes, sir.
Mr. Smith, do you have any objection to me looking at this pay record?
No, sir.
All right. So I've already taken judicial notice of the court's file, which means I have looked at and reviewed all the prior orders in this case. The court is going to note on the record that the court order from 2019 did change custody of the children and gave the children back to Ms. Smith. However, the court order ordered Mr. Smith to pay child support until any of the two children graduated, which is a problem because there's a pretty good difference in the ages between the last two children, that being Grace and Matthew. So the way the court order is written, that would mean when Grace emancipated, Mr. Smith's child support effectively terminated. Now, Ms. Smith said that she thinks that Grace graduated in 2021. Mr. Smith, do you agree with that? Do you think she graduated the year after she turned 18, which is pretty normal?
Actually, she dropped out of public school and she finished.
She still got a
Hold on,
high
Miss
school
Smith,
diploma.
Miss Smith, don't interrupt. All right,
Tell her to
Mr.
tell
Smith.
the facts.
Well, Miss Smith, if you give me a chance, I'll come back to you and let you answer the questions your way, okay?
Yeah.
All right, Mr. Smith, you said she dropped out of high school. When did she drop out of high school?
I'm not exactly sure, Your Honor. She
So that
did
doesn't help me,
complete.
Mr. Smith. If you don't know when that happened, it doesn't help me, okay?
It was her senior year. She finished with a high school diploma through a home education type course thing.
But if you can't tell me when that happened, Mr. Smith, then
In
I can't
2020, I'm almost positive she graduated when she was 2020.
Miss Smith, do you know whether or not Grace dropped out of high school?
Yes, we went out of public school and we went to a home school where I paid
Okay.
for her education, and that's how
Okay.
she.
When did she drop out of public school?
I believe she went her whole senior year to private homeschool.
Okay. So you don't think that she was enrolled her last year in school in a public school?
No, sir, she wasn't. It was through a private school.
Okay. Through a private school, like a
Well-
homeschool.
Yes, sir.
Okay.
She is correct. I just
That's
looked
okay,
back on-
that's okay, Mr. Smith. I haven't asked you anything else yet, okay?
Yes, sir.
Look, guys, you lived through this. I didn't. So I'm trying to catch up with 3 years of history in about 15 minutes. So let me make sure that the history I catch up with is correct, okay?
Yes, sir.
Why did it take the state so long to get Miss Smith to cooperate with their lawsuit?
Because I went to the actual place in Port Arthur or somewhere down there where I'm regioned at to go to the office, and they said I didn't have to do anything, and so I don't know. I'm just now getting emails to do this, so I don't know. I mean, I didn't even request this, so I don't know. What do you mean it's taking me so long?
Well, and this is a lawsuit, Miss Smith, where the state of Texas the AG's office represents themselves. They don't represent either you or Mr. Smith. So
Yes, sir.
in a modification suit, I have the right to go back all the way back to the date the parties were served to start this child support again. Unfortunately, Miss Smith, you were not served with this case until September the 28th of 2022.
So now the child leaves traditional school and finishes high school online after turning 18. And that's exactly where everything gets complicated. Most people don't realize that after age 18, child support typically only continues if the student is enrolled in a state-approved or accredited program. And a lot of online or home-based setups don't qualify at all. IT happens more than you'd think. Parents assume that any form of online schooling counts as still in school, but legally it depends entirely on the official credential, not the effort put in. The court treats a non-approved program more like a personal project than an actual graduation pathway. That's the cold part about family law. The system is driven by documentation, not intentions. In this case, the dad might have fallen into a rare loophole, one that actually benefits him, but it also exposes just how outdated and inconsistent the process can be. One small technical detail can be the difference between owing thousands or walking away completely free.
That means I can't start the child support again until October the 1st of 2022. How did you say that Matthew was covered for insurance, Miss Smith?
Texas Medicaid.
Okay. And Mr. Smith, do you have any other children besides Matthew?
Grace and
that are
Barry.
still underage.
These are my only 3 children.
Anything further from the state?
I know, Your Honor.
Mr. Smith, is there anything else you think I need to know about this case before I make a ruling?
No, sir.
Okay. Ms. Smith, is there anything else that you think I need to know about this case before I make a ruling?
No, sir.
All right. Look, y'all, this is real complicated. You didn't make it complicated. It's not your fault. I didn't make it complicated. It's not my fault. The AG's office didn't make it complicated. It's not their fault. All right. There's a bad court order in this case from 2019 that needs to get fixed. And I'm going to fix that today. I wish I had the right to go back in time and fix it, because this child, Matthew, deserves support all the time. But I can't fix court orders back in time. I have to just fix them and keep moving. Okay. The law doesn't allow me to go back in time and fix it. Okay. So I'm going to fix what I can. And that's what I'm going to do today. The court's going to find the court has jurisdiction. The court's going to find that based on the testimony of the parties and all of the exhibits that have been admitted into evidence, as well as the prior court orders in this case, I'm going to find that as of her birth date in the year 2020, child support terminated. She was not fully enrolled in a accredited high school education program that allowed for child support to continue past her 18th birthday. Homeschools generally are not accredited. It takes special type of licensing to get accredited.
Why?
Ms. Smith, don't interrupt me. Don't interrupt me, Ms. Smith. Okay. I know what the law is in regards to this issue. And unfortunately, homeschooling is not considered an accredited high school diploma. So the child support is going to terminate as of October of 2020. The judgment will be granted as of the end of that month, and I'll find that Mr. Smith was behind in his child support the amount of $1,710.34, behind in his medical support the amount of $25. Effective November the 1st of 2020, child support terminated based on the court order from 2019. That's how it was written. That's how it has to be interpreted. There's no room for me to maneuver within that court order to start Mr. Smith's child support for the last 2 years. I don't have the ability to do it, but I can start it up now. And I am going to start it up now. Starting October the 1st of 2022, Mr. Smith is ordered to pay Crystal Smith the amount of $765 a month in child support. I'll order Ms. Smith to maintain the health insurance that she has on the child, and he will be ordered to pay an additional $150 a month in cash medical. Mr. Smith will pay back the judgment that he owes for child support by paying an additional, let's say $30 a month on the child support, and we'll say $5 a month on the medical support for those amounts. Those will also begin October the 1st of 2022. Mr. Smith will be responsible for court costs, but I'll give him until May 31st of 2023 to pay my court costs. Ms. Leonard, did the state hear all the terms and conditions of my court order?
Yes, Your Honor.
All right. Ms. Smith, Mr. Smith, Ms. Hill Leonard's office is going to prepare a court order for me. As long as it matches what I said here today, I'm going to sign it. I'm going to get it back to them, and then they'll make copies of it and send it to each of you. Now, you don't have to be satisfied with my ruling. There's no other way that a court can do anything other than what I did today, but you have the right to appeal if you wish to do so. If you wish to appeal, your appeal has to be in writing. It's got to be filed in the next 3 business days in the Newton County District Clerk's office. Your appeal has to be specific. You got to state in your appeal what part of my ruling you disagree with, and you're also responsible for making sure that you send a copy of that written appeal to all the other non-appealing parties. All right, Ms. Smith, Mr. Smith, I wish you both the best of luck. I wish there was something else.
Behind?
I'm sorry?
What was the amount that you said he was behind?
As of October the 31st of 2020, according to this pay record that I have, he owes $1,710.34 in child support and $25 in medical support.
Your Honor, what about the child support that was paid since the child support was
You'll have
terminated?
to take that up with the Attorney General's office, Mr. Smith. I don't have any jurisdiction, Mr. Smith, to order the AG's office to do stuff with money. Once
Yes,
they get the money in their hands, they do with it what they wish. That's a federal law, and I don't have the jurisdiction in federal courts.
Okay.
Okay? All right. I wish you both the best of luck. I really do wish there was something I could do to fix that court order from 2019, but I cannot go back in time. The law doesn't allow it, but I can at least fix it from this point forward. You're both free to go. Try to have a good day.
Thanks,
Thank
sir.
you.
All right, thank you both.
It still amazes me how often people forget that child support is supposed to benefit the child, not function like a monthly paycheck for the parent. And from a reaction here, it honestly came across less like concern for the kid and more like someone panicking over a missing deposit. That's when support starts looking more like dependency than responsibility. What makes this even more wild is the fact that Mr. Smith actually overpaid. He was sending money during a period when legally he didn't even have to. And in a perfect world, he'd get full credit for that, but the reality is, the system rarely rewards responsible behavior unless it was done on paper and with perfect timing, if anything. It just lets a confusion sit in silence. And seriously, how do you not know the exact moment your own child graduated in family court? That's not just inconvenient, that's proof your focus may have never truly been on the child at all. So here's the real question. Where's the line between genuine support and financial dependence? I'd love to know what you guys think about how this played out. Thank you for watching. Make sure to like, subscribe, and stay tuned. It helps the channel more than you know.